Once again, my name is Tanya Mehra, and I work at the International Center for Counterterrorism in The Hague. And I would like to thank the Counter-Extremism Project for inviting me as panelist here today for this webinar. And I look very much forward to a fruitful discussion and also to learn more about the repatriation of FTFs from Ukraine. So my focus is going to be on the repatriation of returning foreign fighters from Syria and Iraq to Europe. And I will discuss a few policy options and some legal considerations. Yes, no, it's just a few facts and figures before we start. I mean, it has been now nearly 2 years since President Trump had announced that he would withdraw the US troops from northern eastern Syria. And the estimate is that there are 13,500 foreign women and children in the camps held by the SDF, and in addition, 2,000 male FTFs in prison. It is difficult to give an exact number of how many people, foreign FTFs there are there for different reasons. Some of them might have a dual nationality. Some of them might have been deprived of their nationality. Some countries include the legal and the illegal residents, and some countries are more forthcoming in sharing these numbers. Just recently, in a report by Thomas Renard and Rick Colsett, they have produced their latest numbers they were able to find. So let us look at the different policy options. I have summarized them as follows. The first is basically leave them there. The second is prosecute them locally. This could be either by the Iraqi courts or by the SDF courts. The third option is to impose administrative measures. And the fourth option is reluctantly repatriate them. And the fifth option, which is my favorite option, is that they would be actively repatriated for the actual crimes they have committed. So let us just go through them one by one. If we look at the first option, several European politicians have said in the media that they would rather see them not return anymore back to European soil, and they basically could stay there. This option is quite problematic for various reasons. First of all, I mean, it violates their human rights, but it also there are also many other disadvantages of leaving them there. They could potentially further radicalize in the camps. They could be released, or they could escape. So just to give you an example, I mean, in the camps, there are certain hardliners in these camps, and they have created makeshift tribunals to punish those that do not adhere to the strict interpretation of the Sharia law. And we all know what has happened in Camp Bucca, where the most radical Iraqi jihadists were detained, and which was also considered basically the cradle of IS. Now, recently, the SDF has released Syrian women and children and handed them over to the local tribes. But they may in the future also grant amnesties to our FTFs. And alternatively, they could escape, and they would pose an even bigger security risk to European countries. Some might disappear totally or join other terrorist organizations, or they might show up at the embassy. Another thing what we have seen is that it also encourages family members which are here in Europe to help them to escape. So to give you an example, Samir A., he is a member of the Hofstad group in the Netherlands, and he has been detained for financing of terrorism. And he has helped 10 Dutch women escape from the camps from northern eastern Syria. And his trial is going to commence shortly. So far, accordingly, approximately 53 women and children have escaped. So let us look at the second option. The second option is that some countries seem to favor is local prosecutions. And this could be indeed by Iraqi courts. And as I've written before on this has several problems. Iraqi courts uphold the death penalty to start with. The Iraqi trials do not meet international fair trial standards. The Iraqi prosecute on the basis of overly broad counterterrorism legislation, and the Iraqis have so far not yet implemented international crimes in their own domestic legislation. And this means that they cannot prosecute FTFs for international crimes. But maybe more practically, many, if not all, of the FTFs which are being held in the SDF camps may have committed only crimes in Syria, and this would pose jurisdiction challenges if you would want them to be prosecuted in Iraqi courts. So now let us just briefly look at the other option, and that would be to see whether the SDF would be able to prosecute the foreign terrorist fighters. Now, the first problem is that the SDF is not recognized as a state and is de facto a non-state armed group. So in practice, non-armed state groups have set up their own tribunals to prosecute their own members. Now, to give you an example, the Tamil Tigers have done this, for example. But according to Common Article 3 of the Geneva Conventions, non-state armed groups also need to comply with international standards of fair trial. So this would mean that the SDF has to administer justice by an independent and impartial court in accordance with the fair trial standards. And then there is also the problem of capacity. Does the SDF have the capacity? Do they have enough legally trained prosecutors and judges that can administer justice? And one also should look at the detention facilities and the detention conditions, which is also a problem at the moment in the prisons which are being held by the SDF. So, and finally, European countries cannot issue MLA request or request a transfer of a sentenced person because the FTF is not recognized, and it cannot conclude a bilateral cooperation agreement with the SDF. So for these reasons, prosecuting them locally can be quite problematic. So the third option is imposing administrative measures. Basically, it is trying to prevent or stall repatriation as much as possible. Now, obviously, this is not going to be an official policy which any European country will say, but there are several countries that basically strip the nationality of their citizens in the camps and are basically preventing them to return home. So countries like Australia, but also Belgium, the UK, and the Netherlands have stripped the nationality of their citizens. So to give you an example, in the Netherlands, since 2017, 11 persons have been deprived of their nationality. And the prosecutor's office have concerns with stripping the nationality, as this would hinder prosecutions. First of all, even though trials in absentia is possible in the Netherlands, the suspect is entitled to be present at the trial. And this could be problematic if someone is in the camp and his or her nationality has been deprived. A second risk is that the court would maybe render even lower sentences because they feel that the accused has already been punished because he or she has already been deprived of his nationality. Now, just to give you, an example, a lady in the Netherlands, her name is Fatima, she escaped together with her children last year in November, and she arrived at the Dutch embassy in Ankara. But just days before she arrived there, she was stripped of her nationality. But according to Turkish policy, all the FTFs are now being deported to their country of origin. So you can imagine that this was quite problematic for the Netherlands as well. She got deported, she came to the Netherlands, the children were placed in custody of the Dutch Protection Board for Children, and the children are temporarily at their sister's place, and her trial is still pending. If she would be convicted, she would most likely be deported to Morocco because she doesn't have a Dutch nationality anymore. And what will happen with her children is unclear because the father of these children is a Belgian foreign fighter who has been convicted in absentia, whose nationality has also been deprived. So this just shows how incredibly complicated it can be if states choose to deprive the nationality of their citizens. And just briefly, two other examples. Like most of you have followed the case of Shamina Begum. Last week, the Supreme Court, there was a hearing about her deprivation, the decision itself of the deprivation of nationality and her right to come to fight this decision in the UK. And of course, the Beatles, which I think a month ago have finally been transferred to the United States to stand trial under the condition that they would not, that no death penalty would be imposed on them. These two members of the of the famous Beatles were also deprived of their nationality by the UK. The other side of the coin is making it a bit difficult to prove that certain children are your citizens. And in some cases, countries require that the mothers would allow or give permission that their children would take a DNA test. These tests often have to be borne by the family members itself. So they basically need to prove their citizenship. So just to give you an example, recently 4 women and 9 children from Sweden had escaped the camps in Syria, and they were detained in Turkey. And only after the DNA testing was confirmed, their nationality, they were deported finally to Sweden. So that is the third, basically, I mean, the third option, imposing administrative measures. The fourth option I like to refer to is reluctantly repatriating your foreign fighters. So far, various European countries, including France and Germany and the Netherlands, they have repatriated approximately 60 orphans so far. And as mentioned already earlier, since the policy of the Turkish government has changed, all the FTFs are being, who have been detained are being deported to the country of origin. So far, 73 women and children have been deported. So including the example I just gave about the Swedish 4 mothers and Fatima. So basically, it's not willingly, but unwillingly, they are being repatriated to the countries of origin. The last option is what I like to refer to is actively repatriating the FTFs for the actual crimes they have committed. This does not happen a lot. And I will focus on this a little bit more further down in the presentation. So what are the most common perceived concerns why European countries are reluctant in repatriating their foreign fighters? So the first is a fear of a terrorist attack. The second is that they receive very low sentences. And the third is lack of evidence. And finally, there seems to be a lack of political will. And what I would like to do now is I like to refer to this as debunking the myths. So I would like to go through each of these perceived concerns and look at this from an evidence-based and a rule of law approach focus. So the first one is that actually terrorism recidivism is very low. I mean, we all know the 2 attacks in London in 2019 and in February 2020, and indeed even more recently, the attack in Vienna, were committed by terrorists who were released from prison. And this raises indeed several concerns. So how effective are rehab programs? And should terrorists be eligible for early release? And what is the risk of recidivism? So countries like the UK and Austria are now contemplating whether or not they should change their laws. But in fact, research has proven that terrorists re-engage in terrorist activities, in fact, relatively low. Just to give you a few examples, in the Netherlands, out of the 189 convicted terrorists, 4.2% have re-engaged in terrorism. In UK, the percentage is 3%. And in a recent study in Belgium, out of the 557 convicted terrorists, 5% re-engaged in terrorist activities. So why is this fear of terrorism, recidivism so big? So obviously, some of the large attacks that have been committed by returning FTFs are still very often in the media. Just to give you an example, is the Charlie Hebdo attack by Sheriff Kawichi and the trial which recently started a month ago in Paris. Another factor is the release of many jihadi convicts in the coming years, which is also a lot of people are afraid about that. The continued concern of radicalization in prison, coupled with the fear that de-radicalization programs are not foolproof or effective. So this is helping, or I would say not helping, I mean, it's spreading the fear that indeed a terrorist attack might occur. So when we look at prosecution of returning FTFs, European countries were reluctant to repatriate their foreign fighters. Prior to 2014, countries were struggling to prosecute FTFs for FTF-related crimes. But after the adoption of UN Security Council Resolution 2178, many countries have criminalized preparatory offenses. As a result, you can see that many countries can and have prosecuted FTFs for membership of terrorist offenses, but there are also other possibilities. So FTFs can be prosecuted for ordinary crimes, such as murder or arson. And this, in fact, has happened in the Netherlands with the first foreign terrorist fighter. But what is maybe more interesting to see is that in recent years, you see a shift is taking place in Europe. Several countries like Sweden, Finland, Germany, France, but also the Netherlands are exploring how crimes can be prosecuted as international crimes. So this could lead to higher sentences and provide more justice to victims as the perpetrators are convicted for the actual crimes. So to give you a few examples, a few FTFs have been prosecuted for pillage or even for recruitment of their own children as a war crime. And alternatively, we have also seen some cases where FTFs are being prosecuted for posing next to a dead fighter, which is considered also an outrage of personal dignity, which constitute a war crime. There are also other possibilities. One could also prosecute FTFs for example, for trafficking of weapons, of document fraud, or for sexual and gender-based violence, such as slavery and human trafficking. So basically, you see that the toolkit for prosecution is much larger than only terrorist offenses. And another development which I would like to focus on a little bit is the increasing use of battlefield evidence. So I'm not sure, of course, how many of you are familiar with this topic of battlefield evidence, but I mean, it's quite obvious that prosecutors cannot travel to war-torn countries to collect evidence. And where battlefield evidence was maybe the big unknown 5 to 10 years ago, it is increasingly becoming more common. And also you see that there are more actors involved in the collecting of information from the battlefield, but there's also much more guidance available on how battlefield evidence can in fact be used as evidence in court. So maybe just to clarify, battlefield evidence is not a separate type of evidence. Battlefield evidence can be documents such as membership of a terrorist organization. It can include fingerprints from unexploded IEDs. It can include, for example, media footage, which you can find in mobile phones, computers, or other electronic devices. And it can also even include witness statements or intelligence. So basically, battlefield evidence can be electronic evidence, it can be intelligence, it can be documents, it can be witness statements. So maybe it's important just to emphasize once again that it is the prerogative of the law enforcement and the prosecutors to investigate and to prosecute crimes. That is the case, and that should always be the case, but there are certain exceptions in situations where indeed the prosecutors are really not able to go to certain areas. And it doesn't mean there has to be an actual war going on. It can also be during a high-risk situation or a post-conflict situation, which doesn't allow the prosecutors to actually go there to collect evidence. And in these cases, the military might be able to step in. But there are also other actors which are involved in collecting battlefield evidence, such as the Commission of Inquiry, which is, for example, established for Syria, but also recently in Libya. They also might be able to document human rights abuses, which could be used potentially in prosecutions. I would also like to point out to the IIIM, the mechanism which deals with collecting evidence in Syria committed by all the parties involved there. And this mechanism collects this evidence and can share this with national prosecutions here in Europe or in other countries. Another useful mechanism is UNITAD, and this United Nations investigation team focuses specifically on collecting evidence of crimes committed only by IS and not by the other parties, but they too have been collecting useful information, and technically the information would first be made available to the Iraqi authorities, but since they still haven't implemented in the international crimes in the domestic legislation, the information is now also being made available to some European countries. And last but not least, I would like to mention the specialized NGOs, such as CIJA, the Commission for International Justice and Accountability, the Syrian Justice Accountability Center, or for example, the European Center for Constitutional and Human Rights. These specialized agencies have also been documenting human rights abuses and collecting evidence. And in some cases, this kind of evidence has also been made available to national prosecutions in Europe. It goes beyond the scope of today's webinar, and I would be more than happy to have a separate session only on battlefield evidence, but there are still a lot of operational and legal and practical challenges that needs to be addressed before one could use information collected by the military as evidence in court. There must be equality of arms. One also has to look into the rights of the accused, and the evidence that will be collected must not only be admissible, but it also must be credible and reliable. But there is quite a bit of guidance now in this area. And I just wanted to flag a few of the recent developments in the area of battlefield evidence, and that is there are the UN guidelines to facilitate the use and admissibility of evidence in national criminal courts. The Global Counterterrorism Forum has also adopted what we call the Abuja recommendations on the collection, use, and sharing of evidence, and also specifically addresses battlefield evidence. And in May of this year, Eurojust adopted the Memorandum on Battlefield Evidence. And I believe last month, the NATO adopted a practical framework for technical exploitation of battlefield evidence. So there's a lot of development in this area, which is actually helping to build and collect evidence to prosecute FTFs in Europe. So what I just briefly would like to go over are, what are the grounds to actually repatriate? I mean, the first, I call them the security grounds, and we already briefly discussed that in the beginning. If we leave them there, there's a chance that they would further radicalize, and they would be released or that they would escape. And some of them might disappear and return unseen to European soil years later. What is maybe more important is just to look at some of the legal grounds why we should actually be repatriating FTFs. UN Security Council 2178 and 2396 basically oblige states to bring terrorists to justice. And this is a binding resolution upon all states. And it calls for states to adopt appropriate mechanisms for prosecution, rehabilitation, and reintegration of FTFs and their families. But I also think that EU countries have the obligation to provide consular protection and assistance to its citizens, in particular children, even though if there's no absolute right to provide consular protection. And under the human rights law, states also ought to repatriate. So some of the grounds to repatriate include the right to be free from torture, the right to a fair trial, the best interests of the child, the right to development and education, and there are many, many more. And finally, there are also some moral grounds to repatriate. I mean, we owe it to the victims to bring the perpetrators to justice, and we cannot dump our problems on others. And neither should we risk that our citizens are exposed to torture or even the death penalty. And so they should receive a fair trial. And I think maybe what's even more important to raise is that by not repatriating them, we are fueling the narrative that they are basically second-rate citizens. So to conclude, I think it's time that we start reframing the discussion. We, including myself, refer to them as FTFs, but let's break that down and look at the first F. So they are not foreigners. They are our own citizens, for better or for worse. Their motivation is maybe strange to us at some times, or maybe even foreign, but their nationality isn't. Are they terrorists? Some of them, yes, but not all. As I explained, some of them might have committed ordinary crimes, some have committed no crimes at all, and some have committed even more worse crimes than terrorism crimes, the most heinous crimes possible, international crimes. So even the T is deceiving. And then the last bit, fighters. Are they fighters? Certainly not. We are forgetting that all the children are victims, and the majority of the children are born there. In Netherlands, 90% is under the age of 9. So I really think we should stop dehumanizing them and take our responsibility for our own citizens. The second thing what we need to do is learn from the countries that do repatriate them. I know the situation is very different, but I think it's important to look at countries such as Bosnia, Kosovo, and Kazakhstan to learn what works and what doesn't work. And I think we need to have faith in our democratic and legal institutions. A lot of progress has been made. EU countries have criminalized many preparatory offenses, increasingly have started prosecuting FTFs for the actual crimes they have committed, including international crimes, resulting in higher sentences. And I think it would be better that we would focus on strengthening the use of battlefield evidence in national courts in a rule of law compliant manner. Cases should be, you should start building the cases as soon as possible, way before they actually return back to the country. We should invest in more research in rehab programs to see what works and what doesn't work, and re-evaluate whether post-release monitoring needs to be adjusted. I'm not saying creating a new law, but I'm saying re-evaluating and seeing if there's any room for improvement. And we should realize that in addition to the legal institutions, social services, intelligence, child protection boards, municipalities in many EU countries are ready and have been ready for a long time to actually repatriate their citizens. And I admit there is no such thing as a 100% risk-free society. By bringing back our citizens in a controlled way, it's more manageable and it's less risky than leaving them out there. And finally, I think from a rule of law perspective, repatriation is the way forward, because only then we can also help, help to undermine the narrative of abandonment, grievances, and further radicalization. And it would allow us to bring the terrorists to justice to the full extent of the law and provide assistance and care to the children who need it. So with this, I would like to end my presentation.